Welcome to Green and Red, Scrappy Politics for Scrappy People, a regular podcast on radical environmental and anti-capitalist politics, brought to you by Bob Bazanko and Scott Parkin.
3, 2, 1, and we are recording. Welcome to the silky smooth sounds of the Green and Red podcast. I'm your co-host, Scott Parkin, in Berkeley, California today. And as always, I am joined by
Bob Bazanko from beautiful Mahoning Valley in Ohio. And remember to subscribe and share.
Yep. And so today, we're excited to be talking about a topic we actually haven't talked about in a while. For the last 4 or 5 decades, we've seen the rise of neoliberalism, free trade zones, free trade agreements, lots of treaties around, like multilateral treaties around like trade and economic policy and things along those lines. And as folks familiar with the show or know that Bob and I actually were very involved in like anti-corporate globalization movements. That's actually how we met. And so today we're going to be talking about some of those policies, some of those tools that actually we see corporations and capital use to kind of like etch away at regulation. And so joining us today is Lisa Sachs, who is the director of the Columbia Center on Sustainable Investment. She's a globally recognized expert in the ways that laws, policies, business practices shape global investment flows and affect sustainable development. So this also has a bit of a climate tie, and as folks know, we also talk a lot about climate. So first of all, I want to welcome you, Lisa, to the Green and Red podcast.
Thank you so much. I'm really excited to be speaking with both of you.
And maybe because we'll be talking about probably some like new ideas and some new terms and things that people haven't heard in a while. Maybe actually you could just start off with some of the work that happens at the Columbia Center on Sustainable Investment to sort of like give a little bit of a overview of some of what we'll be talking about.
Yeah, great. So as you kindly mentioned in your introduction, our work at the center is very holistic because investment and where it's directed and with what behavior, into which sectors, with which qualities, how it affects communities and workers and the regions in which investment is directed and so on, depends entirely on the policy framework that governs that investment at the international level, at the national level, at the subnational level sometimes, and then of course of the practices of many economic actors that shape the investment flows. That's the investors, the financiers, can be down to shareholders, and so on. Often the lawyers themselves have some influence over these governance frameworks and so on. So our center really takes a holistic look at, and by the way, we're a mission-driven center, so not only are we looking at, but we're trying to understand how all of these, how the policy framework at the international level, national level, all these levels shape investment so that it can be progressively reformed so that investment flows to where it's needed and in a manner that advances sustainable development and human rights and mitigates the very real and avoids the very real environmental, social, and other harms that many investments have had. The topic that I'm particularly excited to bring to you and your audience today is probably one of the most influential aspects of the international governance framework, but so little understood, not even known by at least the majority of those of us in this country. It's a little better known in other countries, but still so little known relative to the importance that it has. And that is the network of investment treaties or investment chapters of free trade agreements, as you mentioned, that provide protections to foreign investors when they invest abroad. There are more than 3,000 of these treaties between and among governments. The one that most in the US will have heard of at least is the NAFTA, but there are 3,000 of these treaties that provide these protections and include this extraordinary mechanism within them that allow investors to sue governments for a breach of those protections. So while that's one aspect of this complex governance framework for investment, it has extraordinary implications for power dynamics and the ability of states to regulate in the public interest.
you want to kind of go a little bit more into that? Because that's something from way back I remember reading the first time I read it. There were these cases like a Mississippi funeral parlor and a California, I think, gas law or something like that, which took local control or even state or municipal control away. Do you want to kind of just kind of describe how that works? Because
Yeah,
that was always the part, like the economic stuff kind of has a certain market logic to it, but these are like inherently anti-democratic.
yeah. So the premise, which I want to come back to after I tell you about the effect, but the premise of these investment chapters and this protection is the assumption or the presumption that investors face bias or discrimination in foreign markets that inhibits their investment flows, and that in order to facilitate investment and to encourage more investment flows, with the further assumption that those investment flows will contribute to sustainable development. So in order to encourage investment that will then lead to sustainable development, the premise is that we need to provide investors with these legal protections to protect their investments, to protect them against discrimination or expropriation, and to give them the right to bring claims directly against governments, not in the domestic judicial systems, which again, the presumption is that those domestic judicial systems are biased or corrupt or too slow or whatever. So this mechanism allows them to bypass those domestic judicial systems to bring claims directly against governments. I want to come back to whether any of those presumptions stand after, but to tell you about the effect that this has, it's pretty extraordinary in international. Two things about this mechanism are extraordinary. One is that it bypasses any domestic legal systems, which, as anyone can imagine, are decisive in balancing government prerogatives and government interests and communities' interests and communities' rights against private interests and so on. Domestic judicial systems have evolved over decades, over centuries, to balance, or to find a balance, I should say, between states' prerogatives and their responsibility to regulate and to protect the public interest, the rights of individuals to know about cases in the judicial system, to participate in those, but also to protect private property. So we have a number of procedural and substantive doctrines in domestic law that have evolved to balance those many complex interests. This mechanism allows investors to bypass all of those mechanisms to bring claims in confidential arbitration hearings. Sometimes there's no obligation, I should say, of transparency. So we don't even know the extent to which these claims are being brought. And when we do know claims are being brought, we often don't see the hearings. We don't know any of the facts. Those who are affected by investments don't have the right to participate and so on. So they are really confidential hearings heard by by 3 arbitrators who are appointed by the parties, and they are making judgments about the legitimacy of a government's actions and whether whether their regulations are fair, appropriate, and so on. That in and of itself is pretty extraordinary, but it wouldn't be so extraordinary if the claims we were seeing were claims that alleged that indeed governments were discriminating against a company on the basis of their nationality, or they were expropriating property, or they were really treating these investors unfairly. What is really shocking about this system is that the claims that we've seen in the past 20 years, because this is a historically new, you were probably fighting these treaties when they were being negotiated in the 90s, but these claims we're really only seeing in the past 20 years. What we've seen in the past 20 years is the measures that are being challenged are not allegations of bias and corruption and expropriation, but they don't like the government's implementing new environmental regulations that would prohibit a mining project from proceeding, or that would require more expensive environmental management techniques. They don't like requirements to have to consult with local communities. They don't like when taxation is adjusted because the government realizes that a previously agreed taxation framework was unfair to the state. They don't like when governments have implemented compulsory licensing for life-saving medications. The measures that have been challenged are legitimate, non-discriminatory measures that governments are taking to protect the public interest, to protect public security, and so on. And government and investors are bringing these claims to these party-appointed arbitrators who are then deciding whether indeed the investors' protections, their entitlement to non-discrimination and so on, were breached. The last thing I'll say is even that wouldn't be extraordinary if the arbitrator said, "Are you kidding me? This is a non-discriminatory environmental regulation." Or this community is protesting this mine. There have been violent outbursts. We need to pause. We can't review this. We can't approve this licensing right now. That's an absolutely legitimate measure. But that's not what the arbitrators say. The arbitrators largely find, or too often, I should say, they find in many cases that these absolutely legitimate public interest measures are indeed violate a breach of fair treatment to these investors or are discriminatory for whatever reason. So the outcome, the effect of all of this is that states are frequently ordered to pay hundreds of millions, in some cases billions of dollars, to investors for having had the audacity to carefully review an environmental impact assessment or to denying a permit for a project that will have massive impacts or whatever it is. And those awards are highly enforceable around the world. And states are now chilled by the potential of these suits. Now all the investors have to say is, if you pass this measure, we're going to bring a lawsuit. And so the governments roll back the regulation. So we're seeing evidence that governments are not taking the measures they otherwise would have taken to protect the environment, to advance their climate objectives, to protect the public interest, and so on, to develop their regulatory framework because they don't want to face an expensive dispute from an investor.
And so these arbitration panels, where it sounds like the parties choose them, but is there a sort of where are they, like, I'm guessing they're not just like randomly chosen. I know that there's like a number of like transnational institutions which sort of like govern these treaties, like you're thinking about the World Trade Organization and groups, things like that. Where are the judges on the panels coming from that are being chosen?
It's a great question. So it could theoretically be anyone, just to your point, because the parties can appoint whomever they want to appoint. And I emphasize that because there is no standard for the qualifications that the arbitrators have to have for their understanding of the domestic context, for their familiarity with human rights law or with environmental law or with climate commitments. There are no standards or expected knowledge of any particular area. But what's even more notable is, or I shouldn't say what's more notable, but what happens de facto, these arbitrators get paid a lot of money. So it's a good job. And so arbitrators want repeat appointments. So many of these arbitrators have made a name for themselves by fiercely advocating on behalf of of whoever appoints them. And they therefore get repeat appointments in a number of cases. So what could have been, and I don't know what's worse or what's better, but what could be a broad universe of arbitrators is really a largely boys' club of mainly arbitrators from the West, even though it's mainly emerging markets that are being sued, emerging markets in developing countries. The arbitrators are mainly men from Europe and North America whose record in these cases is known to the claimants. There's actually a famous, or there's a very well-known lawyer in this space who represents states. And he has said that you know what the outcome of a case is going to be when you know who's on the tribunal, because these arbitrators are so known for their past cases. not only is there no qualification that they need to know public international law and environmental law and anything about sustainable development and anything about the domestic context in which these very complex investments are taking place, but there's also extraordinary limited limitations on conflicts of interests among the arbitrators. So there's pervasive, what's called in this field, double hatting, which is that an arbitrator can be sitting in judgment in one case, but acting as a counsel in another case, where there are clear conflicts. Because if you can make law in one case that will be helpful to you as a lawyer on behalf of an investor in another case, that creates a clear conflict. And these same individuals often act as experts in other claims, and they act as advisors to now, and I'm going to throw another log in the fire, there's now a whole funding industry that has grown up of litigation funders who are investing in these claims for profit, third-party funders, who are not investing, who are not bringing these claims even under the pretense of having been wronged as investors, but they see a real profit potential that they can fund a case against a developing state and secure such high awards from that state that they can make thousands of % profit for their securitized investments. And these arbitrators and lawyers on behalf of counsel also advise these third-party funders as to which cases they should choose, the strategy, and so on. So the conflicts of interest among the decision makers are absolutely rampant.
Those are $1 billion slip and falls, you know.
Unbelievable, really unbelievable.
Kind of, this is great because it's kind of like a globalization 101. Do you want to kind of just give also like in that vein, a general overview of things like NAFTA and the WTO, how they, what they were intended to do with regard to things like tariffs and regulations and labor and immigration and things like that? Just kind of.
Let me give a very limited perspective because it is such a huge area. But one important thing that I have that I think is useful to reflect on, and actually you may usefully complement this from other directions, but this goes a bit back to what I was saying about how I wanted to revisit the premise of these agreements and what the original objectives are of these international institutions that are core to our international governance. To avoid speaking on this for an hour and giving an hour-long lecture on this history, I think I would just emphasize one important point that has come up for me. We also did another project recently looking at the implications of some of the recent or some trade agreements on labor rights and environmental rights and so on that brought us back to look at the history of the negotiations of the WTO and some of the language in the framework. And my naivete, and as I was getting into my career, actually thought that these institutions were designed because some cooperation around economic governance would be helpful to achieve our global goals and to manage environmental impacts and to address aspects of economic governance that had transnational considerations, required transnational governments, had transnational implications. I thought that that's what I would find when revisiting the history of these structures. Let me speak more to these investment treaties, just given the limited time, than the WTO, which is absolutely worth another full discussion. But I would draw one distinction between the two and then elaborate a bit on the treaties. In principle, the idea of it, to my mind, but I'd be interested to discuss this, but in principle, the idea of an international institution to help set rules of trade, in principle, to resolve areas of inequity, asymmetry of power, asymmetry of skills, and so on, I think has a premise. It's not the premise on which the WTO was designed, and it's certainly not the role it's currently serving. But I think that there's a legitimacy to an institution to help resolve or to address aspects of global trade. I see no relevance for these investment treaties, of which there are 3,000. I said I was going to come back to the premise. The premise was that the premise is that we need investment to achieve sustainable development, and that in order to achieve increased investment flows, we need these protections for investors. Those are both fundamental presumptions and assumptions that underpin this network of 3,000 investment treaties, and neither of them is as simple. One of them is more complex, and the other one is just has been fundamentally disproven. The one that's not as simple is the suggestion that any investment leads to sustainable development, and I think everyone now knows that, but it still underpins this whole governance framework and the investment regime and the investment facilitation conversation that is happening at the WTO and others, which is just this simple premise that all governments want to attract more investment. They need more investment because that's how we're going to achieve sustainable development. Of course, that was what I said about the premise of the center. That presumption is fundamentally flawed. A lot of investment is important and good, but whether benefits accrue and the extent to which the harms are mitigated and avoided depends entirely on a robust and complex governance framework. And that current governance framework is fundamentally flawed. So we have a lot of investment that causes extraordinary environmental harms, climate harms, human rights harms, labor harms, global inequality, and so on. So the basic presumption that more investment is necessarily good is not right. I'm in favor of increased investment flows, but thoughtfully, where do we want investment, in what form, on what conditions, and so on. The first presumption has been massively disproven, and it is the linchpin of this whole mechanism, which is that in order to get those increased investment flows, investors need these investor protections. There have been dozens and dozens of credible empirical studies that have tried to establish whether these investment treaties have indeed led to greater investment flows, and they failed to show any evidence. I edited a book on that in 2008, and at the time, there was no conclusive evidence. And then in 2021, there was another meta-study of 74 empirical studies that said that the effect of these treaties on investment flows was so negligible so as to be considered zero. So we have this whole system of 3,000 investment treaties, each of them with this investor-state dispute settlement mechanism. I don't know if I ever named it, but that's what it's called, the investor-state dispute settlement mechanism. We call it ISDS for short, that gives these outsized protections to investors that are directly enforceable in these very powerful ways, with massive awards that are being awarded against impoverished states in favor of these investors and these litigation funders and chilled environmental regulations, all based on this faulty, this inaccurate premise that this is increasing investment flows. I find that extraordinary.
One question I have, I'm actually thinking about a couple different directions to go here, but I would actually ask, could you actually name a couple of the sort of more egregious cases that we have sort of seen?
Yes.
I know that I've seen a couple in the news, but I'm just wondering if you could name some of the more egregious cases.
So yes, and there's so many egregious cases, but let me briefly name a few to give a few. To start with one right at home, the Trans-Canada pipeline, the Keystone pipeline in the US. Actually, let me just say that's the one I
was hoping you were going to talk about.
Okay, good. I'll start with that. But I actually want to start with the premise of that and so many of these other cases, which is for large-scale investments of any kind, but especially in my specialty is in natural resource projects, because of their outsized impacts, both potential, but really the complexity of these projects and how many interests are affected and the massive environmental risks and so on. So that's been my area of focus, is these natural resource projects. These natural resource projects are governed by an important complex system of licensing and permitting and reviews that are designed, because of the complexity and because of the outsized impacts of these projects. Every domestic judicial system, every domestic system has in place a number of processes that investors have to go through to get approvals for their projects. They need to undertake certain environmental impact assessments. Sometimes they need to consult with local communities. Communities need to have a right to contest, or they often have a right to contest certain permits and so on. But these projects need to get multiple permits in order to proceed. And that's a inherently important process to, again, realize the benefits and especially to ensure the harms. Many cases in the system relate to or based on investors, or let me say, many of these cases relate to governments not approving certain permits along the way. And then the investor says, we were assured we would get this permit. It's not fair to deny this permit. We took all of these steps on the presumption that we were going to get this permit. And what the arbitrators say is, yeah, that's right. You could have fairly expected that you were going to get that permit because so-and-so local official told you that the project was going to go forward. That's what a lot of these claims are based on. So the Keystone Pipeline project at its root is fundamentally that, which is that Obama denied the permit because of concerns about that we all share about the impacts of the project, particularly, but not only because of its inconsistency with the US climate goals. And that's the basis, on that basis, for not having gotten an approved permit, TransCanada is suing the US under the NAFTA for $15 billion. And where does that amount come from? And I will tell you some other cases where that amount is extraordinarily high, because this is also an extraordinary feature of this system. The claims relate not to the sunk costs. Oh, we had already undertaken these costs in expectation of getting this permit, so you have to make us whole. What is considered making investors whole under the system is that the government pays all the future lost profits that the investor would have made had it gotten its permit, or had the government not taken whatever the challenged measure is. So that's when we get to $15 billion. It's the investors, in this case, claim about what the future lost profits have been, leaving aside all questions about whether any fossil fuel-based infrastructure project has actually a future revenue stream of $15 billion, which is a real question. You know who's going to decide that? The party-appointed arbitrators who have no expertise in any of this. So that's one notable claim. Another one that just, to my mind, really emphasizes the insanity of these process that overrides these domestic systems is a proposed mining project in an environmentally vulnerable, relatively impoverished region in Pakistan, where once again, as in many of these extractive projects, many of these mining projects, the potential impacts to these local communities are outsized. So there was a lot of opposition to the mine, as there often is. And by the way, the incentives now created by the system is not that they resolve and work to mitigate these environmental impacts, but this creates, as I've written in other places, a moral hazard situation, because you don't have to resolve the local concerns. If the project doesn't proceed, you can just bypass the whole system and say, this wasn't fair, we thought it would proceed. But what's notable about that case in Pakistan, so there was a proposed mining project where a couple, let's say $100 million, I don't even think it was that, had been invested and by the way, when we say had been invested, a lot of that is the salary of those in headquarters and the lawyers of those in headquarters. So I don't know how they count their costs, but it certainly wasn't what was invested locally. And the mining project needed water permits, it needed land permits, it needed to agree on the fiscal terms of the project, it needed to get the community approvals, and so on. Those are all critical steps in getting approval for a mining project. Well, it didn't. It stalled because the mining project couldn't agree with the government on many of these critical terms. That's the risk in mining projects. You work hard to get agreement. If you don't, the mining project doesn't go forward. Or you bring a claim. And so they brought a claim at the World Bank. The World Bank, by the way, another extraordinary feature, houses one of the institutions that hears these claims. The arbitrators can be from anywhere, but it's the World Bank, our development organization, that is housing these claims. So the World Bank housed a claim brought by this mining company against Pakistan. And rather than the arbitrators saying, well, you didn't get that permit, you hadn't agreed on this, this is reasonable. That's what happens in mining projects. They said, yeah, you were right. You had gotten all of these these assurances that the project would go forward. So you're entitled to lost profits. Well, how can we figure out what lost profits are? Because there was no contract. So the arbitrators say, not a problem. we'll imagine that you got this, we'll imagine that you got these licenses, these permits that you hadn't gotten. You wouldn't have been able to actually meet the water use requirements, but the government would have overlooked that requirement. The government would have constructed, this is the fiscal regime that the government would have agreed to, including fiscal incentives. So the arbitrators gave the company standard fiscal incentives in the fiscal regime, constructed this whole contract that didn't exist and awarded to this investor that had a project that had never gotten off the ground $4 billion in lost profits, another $2 billion in interest on that award. So Pakistan was ordered to pay $6 billion to this mining project for a project that had never gotten approvals, never gotten on the ground, was hotly contested locally, and so on. That $6 billion, by the way, by coincidence, not by design, almost exactly to the dollar, the same amount of an emergency IMF bailout package to Pakistan earlier in that same year. So that's another one of the cases I find. Oh, and then let me just tell you what happened in that case, because it's also part and parcel of this system. And this happens, which is that, as I mentioned, these awards are highly enforceable around the world because there are a couple of other treaties. Well, there's this World Bank ICSID treaty. ICSID is the International Center for Settlement of Investment Disputes. They have a treaty that most governments are part of, and the New York Convention is another treaty that most governments are party to. Those treaties require states to enforce arbitral awards in their courts as if they were domestic awards. So they basically they require states to honor these arbitration awards and to allow investors to enforce these awards in domestic courts anywhere around the world. So investors can go to, in this Pakistan case, and they did go to England, go to elsewhere to seize the assets of Pakistan if Pakistan doesn't pay up. So they can take these enforcement procedures all over the world. Pakistan can now find itself fighting in 3 different jurisdictions about enforcement of this award. So what frequently happens after these extraordinary awards is that the parties settle, which the states sometimes claim as a victory, which I think, I'm sorry to say, I think in Pakistan's case they did. They said, we managed to get out of a $6 billion award by settling for $1 billion, plus some undisclosed terms that probably allowed the project to continue. I don't know. The settlement was not disclosed. Whereas again, in domestic legal systems, settlements are required to be disclosed, reviewed by a judge. The public can review the terms of the settlement and so on. There's none of that in arbitration. So after these extraordinary awards, either you see assets being seized around the world to enforce them, or that countries are forced into settlements.
And
Sorry, go ahead.
And if the states, have to pay, then that comes from public money, right?
Of course.
So you have transfer of public to, kind of socialized debt and to these private corporations. Yeah.
And not only to these private corporations, but can we just go back to the fact that so many of these cases are bankrolled by these third-party funders? So they're not even going, I can't even believe I'm saying this, as if it would be a good thing if the public coffers of Pakistan, Ecuador, Venezuela, and others were going into these companies that were supposedly aggrieved, which I highly contest again. But it's not, these cases are now, they're being bankrolled, like I said, by these third-party funders. So their countries are paying into tax havens, these funds in tax havens that are then paid out to investors around the world. There was another extraordinary case against a developed country, because some of these cases are against developed countries too, which actually leads me to an interesting and important development, which I'll mention in a moment. But there was a very recent case last year. So the award was published last year against Italy. Italy had prohibited offshore drilling within 12 nautical miles of its shore, and an oil company sued because that undermined their investment and won for 190 million euro, I think it was. That case was bankrolled. The initial case was financed by a third-party funder. So the third-party funder got the proceeds of that, the oil company made some of it, and then the oil company sold the rights to the claim, the rights to the 190 million euro to yet another litigation funder to go after the assets. And so it took home 50 million euro, and it said explicitly in its press release to its shareholders and its stakeholders that it was using these proceeds to go drill in the Falkland Islands. So for those of us who are a little bit concerned about the climate, this was just the most exasperating case. An oil company challenging regulation that prohibited nearshore oil, and with the revenues from a case that they shouldn't have won, they're now financing further drilling. But that's how the system works.
Rules-based international order.
Yeah, exactly.
The companies where when the companies are trying to seize assets in particular countries, is part of the reason that like the UK or the US, where these assets are being held because they're also sort of like have agreed on these treaties as well? Is that what allows them to do access? And so like, not all countries have signed into these agreements. And so if they are holding the assets, would it be harder for a company to seize them?
Yeah, and then this got me to the point I wanted to also say about the EU system. And this won't surprise you or any of your listeners, but the whole system, even though it's arguably international and there are treaties that are intra-regional, so you see treaties among global South countries. Of course, the whole system was designed to protect capital export, to protect capital exporters from capital exporting countries. That was how the whole system is designed. So who has been advocating for this system, supporting it, et cetera, around the world? Of course, the developed countries who are, especially, by the way, Canada, because of their natural resource investments around the world, anywhere that they have mining projects, they're pushing these treaties. China now, now that it's become a capital exporter, it also is pushing these treaties that have ISDS. So really anyone that has capital exporting interests is the one mainly pushing these treaties. And that's indeed where the investors go to enforce the awards, because in our global economy, many countries have assets in those same large financial hubs or in the main countries where they can go to protect it. Let me give you two other examples, though, of interest. And because I would say that there are cracks in this system. It's a sturdy system, but there are cracks, and those cracks are notable. And that's why it's time to pay attention to this system and to wake up to it and to advocate for it. So first, not quite a crack, but a recognition of the problem. There was an award against Canada for a mining quarry that a review panel of a proposed mining quarry, a non-binding review, had said that the project would have an implication for community values, or an impact on community values in the region. And on that basis of that review, a permit had been denied, or the project hadn't been approved. And the quarrying project sued Canada, saying that to make any decision on this concept of community values was a breach of the NAFTA. And they won that claim. Canada, there's extraordinarily limited potential to try to appeal, and you can't even really appeal. All you can do is to try to have a court review the decision to see if there were tremendous errors of judgment or if it violated public policy. So Canada tried to do that, and the case was heard by a Canadian judge who ultimately upheld the award because the judge said that they had under the law, they had no means to not uphold this award, but the judge who upheld the award said that they have real concerns that the outcome of this case would have a chilling effect on environmental policy in the NAFTA states and the ability of the NAFTA parties to regulate their environmental matters. So the judge recognized that the outcome of this case would have that effect, a chilling effect on environmental regulation, but had no judicial power to overturn it on that basis because the means of limitation are so extraordinary. We're now seeing some recognition in the developed states, because some of these claims are against developed states. The developed states don't want to be sued under these treaties, and there are expensive cases against developed states. So what we're now seeing, which is interesting, but again, a bit exasperating for all the reasons you can sympathize with, but mainly good and mainly interesting, is that developed states are starting to retreat from the system vis-a-vis internal investment. So the most recent and quite notable development is that one of these 3,000 treaties is called the Energy Charter Treaty, and it is a multinational treaty with about 50 treaty partners. And it looks just like all these other investment treaties. It protects investment, but specifically with respect to energy investments. So many of the recent claims that have challenged fossil fuel phase outs, coal plant phase outs, changing fiscal regimes for renewable energy, a lot of the cases that have challenged critical energy transition related measures have been under the Energy Charter Treaty. One by one, European states started to say, we're out of this system. And it was pretty extraordinary. And the Secretariat of the Energy Charters Treaty was panicking, really panicking, and trying to defend it. But one by one, the European states pulled out of it until the whole European Union just withdrew from the treaty as a bloc. But so that's very notable. Why that's particularly notable to me is because there is nothing extraordinary in this treaty that's not true in every other treaty. So if they recognize that they were overexposed or just exposed to risk in this treaty, I hope they realize next they're exposed to risk in all these treaties. But more importantly, let your treaty partners get out of it too. Don't be so Eurocentric that you can't be sued, but they haven't said anything to the development partners, or sorry, their capital recipients, the poorer countries, the developing countries, that they too should get out. And actually, there was a quite interesting televised or public hearing in the House of Lords in the UK, where I had never seen this and I found it remarkable, and I'd like someone to explain the dynamic to me, but the minister was being questioned by a number of the members about this ISDS mechanism in the treaties. And the minister kept saying repeatedly, he had one sentence that he kept saying repeatedly, the UK is assessing its own exposure and is managing its own exposure. The UK is managing its own exposure. The UK is managing its own exposure. And then some of the members were saying, but can UK investors use this mechanism against developing countries? And the minister said, well, that's the developing countries' issue. That's their legal framework to review. So that's where it stands, which is that developed countries don't want the exposure, but by no means are allowing developing countries off the hook. And then just the last point I want to make on the interests of the developed countries, among others, is that there is now such entrenched interest in this system that people can't see beyond the tip of the nose. That's what's exasperating to me. We have no evidence that these treaties are helpful from an investment perspective, never mind from a development perspective. The cases that are being brought have nothing to do with corruption or bias. They're challenging legitimate measures. There's no evidence that domestic judicial systems can't handle these normal disputes. So all of the underpinnings of this system don't support the continued existence of this. But in all the reform discussions around this system, the reform discussions are so limited. Oh, let's maybe have a code of conduct for the arbitrators, or let's maybe put in some more exceptions, or, it's just absolutely, as I have said, I think I'm quoting others in the field, putting Band-Aids on a massively leaky bucket, or, I mean, it's even worse, putting Neosporin on gangrene. There's no real discussion at all about whether this form of governance, of investment governance, meets the needs of the 21st century. It doesn't. Is it serving its purpose? No. Do we have real transnational governance concerns that we could really be addressing? Yes. We have massive concerns in our international governance framework that are exploitative and perpetuate inequality and so on. There are many things that we could and should be addressing in an international governance framework. None of that is addressed in this context, but we're not even having that discussion.
You've talked a lot about the anti-democratic nature of these transnational agreements, which I think is really an unknown part of that. So that's really important. But what about the kind of nuts and bolts application of it? Because the two places where I live are Texas, where we had this explosion of maquilas along the border. And then right now I'm in northeastern Ohio, which turned to Trump, I think, more than for any reason because of NAFTA. And so we have jobs being lost, or perception of jobs being lost, wages, this transfer of jobs initially to southern states and then into kind of the so-called third world. So do you want to talk just a little bit about the kind of way it actually applied to real people, to workers, and to
Yeah.
tomato farmers in Mexico who are being driven off the land and things like that.
Yes, yes. And it's interesting because it has created weird bedfellows. The outcome of this has created some interesting bedfellows. The effects that you're describing, which are real, are the effects of the even broader, which you've repeatedly correctly embedded this conversation in the broader trade regime, because many of these investor protections are embedded in multi-chapter, more comprehensive trade agreements. Not all, but many are. And those trade agreements include even more preferential, all sorts of terms that govern broader trade and have even greater implications for workers and environmental protections and so on, even outside this, what I think is really significant, but somewhat more circumscribed mechanism, which is really related just to investors' rights and doesn't necessarily relate to mobility of labor and so on. This opens up a whole other can of worms, but what I would say is that okay, let me talk about the strange bedfellows too before I say my potentially controversial remark. The funny bedfellows is that Trump and Lighthizer, his US trade representative under his administration, were also against ISDS, as were the progressives on the far left, and Warren,
like the
and
Bernie Sanders.
yeah, exactly. Bernie Sanders, Senator Warren, they have been also outspoken against it. Lighthizer and Trump, but Lighthizer maybe especially, his concern was that these treaties provided free insurance to companies that were offshoring US jobs, and which it is. I mean, this is just a free insurance for investors. And so that it contributed to the offshoring of US jobs and undermine the sovereignty of states. And by the way, I think that that's also absolutely true. Can you even imagine if the US will not lose a case? You know why? The US will not lose a case because if an arbitrator were stupid enough to rule against the US, the whole system would end. So we actually wrote this paper, my colleague did 7 or 8 years ago, showing how the US had lost on issues in ISDS, but it never lost on a case. And that's because if the US ever loses, can you even imagine the uproar if a Mexican company or Venezuelan or whatever, whoever is a Chinese company challenges a legitimate measure that a government takes, and we are required as the U.S. to pay out that foreign investor? The American people would say, "What the hell?" Which, of course, is what's happening all over the world. So that was a concern of Lighthizer too, was the sovereignty and the jobs concerns. That's where we're in the shared bed with our strange bedfellows. Where I come from at the center is that no single the world is complex and the global economy is complex. And I don't think that having a global economy is inherently problematic, but it needs multiple policy components and considerations at an international level and at a national level to ensure the distribution of benefits. And trade agreements without domestic measures to ensure a distribution of benefits in the form of safety nets, job training, job creation, public university, public education, then you end up with these extraordinary consequences for US workers as a result of trade. I think it's complicated because it's not inherently the trade that causes those consequences. It's the trade in the absence, to my mind, to my understanding, of a appropriate domestic governance framework that distributes the benefits. And I think that's true at an international level also, that trade will create distortions. A global economy has inherent distortions. And the role of governance, to my mind, domestic and international governance, are to address those distortions and to ensure benefits for those who are not benefiting from the system. We don't have that. We don't have that at a domestic level at all. We don't have that at an international level at all. And we see the consequences: massively unequal gains and losses within our country and across countries. So I hope that somewhat answers your question. Trade agreements, in the absence of a robust framework to ensure the distribution of benefits is destined to cause the uproar that it caused. But I'm just not sure that we're having the right conversation around what the appropriate policy measures are.
We're getting near the end of our time. I was going to see if Bob had any last questions.
I've
I
got
had
like
one.
3 hours worth. So
I
no,
do
this is
too.
fascinating, and I haven't really kind of talked about this for a long time. So this is really fascinating, and just brings back, kind of so many ideas about it. Actually, the last thing I'll ask then is it's more about the kind of politics of it, because when the Brexit vote was taken, what struck me, and you just mentioned strange bedfellows, which is a great segue into it, because I thought, well, it's people like me who've been fighting these supranational agreements, but Brexit was this kind of right wing, kind of ethnocentric, atavistic movement, and we're kind of seeing that now with Trump's people who are on these issues. Like you said, it's makes me uncomfortable, but on some of this stuff, they're saying the right stuff, right? Where does the politics of this headed? You have these kind of right-wing movements who are embracing this, and they certainly don't share the same agenda, as I do, and probably, don't either. So I just kind of wonder where you see this headed.
Yeah, it's been a remarkable year for me. I will say that never have I seen things in such a nonpartisan lens, because in my view, both parties are terrible. Both parties are terrible. And so we have a lot of bedfellows that realize that now. Both parties lie a lot. Both parties protect the interests of specialized interests. So to me, this is not a partisan issue. We've had Democrat in power for 4 years, and what do we have to show for that? No improved domestic policies. The most tragic and devastating foreign wars, can't even wrap my head around the number of lives we've lost. That's not a Democrat, that's not a liberal value in any way. So I think we've transcended partisan thinking on these issues. Sadly, I don't know that we've transcended partisan politics. To the contrary, it seems like every discussion in politics is purely partisan. There is no individual thinking in either party. You stand by the position of your party. So we have a not disenfranchised, I'm looking for another word, but a whole populace that realizes the system is massively broken, that's tired of being lied to, that recognizes that their interests are not being met. So a whole disenchanted populace. And then these two insane choices at the top that don't reflect any of that. So where do we go from here? I don't know. I see no good outcome in November, honestly. No good outcome. I don't know what we're going to do. But I hope that with your help and your platform that you have, and educating our colleagues and our friends and our families and so on, in our neighborhoods and our communities, that we can change the platform. I think that this is going to have to come from a popular movement. I don't like electoral politics. I don't think in terms of 4-year cycles. I think we need to have a more educated, more informed conversation within the country about what our real values are and how that's reflected in policy. And I hope that we have a new politics that emerges from that.
Can I ask one more quickly? Because it just came to mind. In the last few months, or maybe a year, I've seen several articles about insurance companies now either refusing or raising their rates because of the effect of climate change. So you have these mega gazillion-dollar corporations now who are kind of working against global warming. Is that it? Is there anything in that?
There's so much in that. Where do we even begin? Because the other hat that I wear, my other major area of focus at the center right now is on the finance system and all the financial actors, and the absolute incoherence of the financial system. The way that we talk about climate and the intersection between finance and politics is as inane as the whole conversation that we just had now. Across every sector in our economy, we have corporate-driven policies that are contrary to public interest, public views, and so on, and that are driving decision-making. And then there are these weird pockets, like in the insurance company and others, where I actually think that that even their approach is absolutely incoherent, and we're all going down with them.
Right.
So that is but I would love to discuss with you that at a whole other conversation, because I think that the incoherence and the insanity of the US financial sector and the policies around financing as it relates to climate change are absolutely exasperating.
The uninsurability crisis, I think, is what they're calling it at this point. I'm going to actually leave it there. I think kind of you touched actually on what my question was going to be around as well, which was on the domestic policy. I knew Bob was going to also go for that question too, but the domestic policy question. And want to thank you for joining us today. This has actually been really great. I think this we're going to look forward to putting this one out and promoting it.
Yeah.
Right.
And we'll definitely have to talk again, because there's so much to this. So
I'd love that. These are rapidly evolving areas, and one of the things that I love about our center is really understanding and recognizing the interconnections in these different areas of law and policy and domestic politics and international politics and all of that. So we can talk about all of the wonderful areas that you've touched on that merit their own discussion. But I've also really enjoyed the discussion, and look forward to continuing.
Yep. Folks, you've been listening to Lisa Sachs, who's the director of the Columbia Center on Sustainable Investment. If you like what you hear, and check us out on Facebook, Instagram, and Twitter. If you want to make a donation, go to greenandredpodcast.org and hit the support button, or become a patron at patreon.com/greenredpodcast. And we'll talk to everybody again soon. Go out and make trouble and misbehave. Catch you later.